Live now.
It's live. All right. We'll give it just a few more seconds for everyone to join in. Everyone knows the ground rules. If you guys have any questions, feel free to go ahead and type them in on the Ask Me button, or I believe it is, what's the box called?
Chat box.
The chat box. Okay.
On the right-hand corner.
I'm not sure which version you have in front of you, but usually it's up in the right-hand corner. So feel free to go ahead and ask any questions. Today's topic is basically dealing with lawyers, dealing with difficult lawyers, even more specific on that. And not that lawyers try to be jerks or difficult or cause problems, but a lot of it boils down to really experience. And so what is that lawyer's experience dealing with personal injury? What is that lawyer's reputation of dealing with personal injury, dealing with the different physician offices out there who treat the patients? And there's a few things that come up from time to time that if you're at least aware of it, maybe you can navigate through these problems, have a little bit more information on dealing with these problems. And of course, the whole idea is to move it to a quick resolution so you can get paid. Obviously, we started this whole series starting with the lien and the different insurance issues that come up from it, the different problems that come up along the way that compete with your lien issues. And of course, dealing with lawyers is part of that process. So really, I think probably the first thing you guys should know is that lawyers have a duty of professional ethics. We are bound by statute to do certain things. One of the very few professions out there that really have a code of professional responsibilities where we can actually lose our license. As you have your own ethics rules, if you do certain things, you can be held accountable and lose your license. Lawyers can. We're generally not suspended or reprimanded for serious things. We're basically disbarred. And so that we're kicked out of the profession of being a lawyer. Can't go to another state and be a lawyer. So we take them very serious. And with that, one of the rules we have to follow is Rule 1.15. Of all the rules you should be aware of what lawyers' duties are, this is one that you really need to know. Rule 1.15 really is the lawyer's duty to protect the property of third persons. Said another way, it's the lawyer's duty to protect your lien, because that's your property against someone's settlement. And the third person, you're the third person to your patient and lawyer's relationship and to their settlement. You're a third party. So Rule 1.15 basically says that a lawyer has a duty, once they know that you have a lien in place, the lawyer has a duty to protect your lien. And if he settles the case on behalf of his clients, he has to promptly pay your lien. And if he disputes it, he has to promptly resolve that dispute and promptly pay you the undisputed portion. So let me break that down a little bit further, and we'll take it piece by piece on that. Rule 1.15, write it down, because that's your sword right there. Rule 1.15, again, is the duty of the lawyer to promptly pay you as the doctor for the monies that you have liened into your patient settlement or court award. Promptly. What is prompt? I would say prompt basically is how long did it take for that lawyer to declare a fee on that settlement and deposit his fee into his account. That same time frame would be how long it should be for you to get paid on yours. Really, that to me is what prompt means. How long did it take for the lawyer to get paid? Is how long it takes for you to get paid. The problem sometimes is that disputes can arise. Now, the disputes have to be legitimate disputes. It can't be just because the lawyer thinks that your bill's too high, or because he disagrees with the chiropractic philosophy of some reason. The dispute has to be a bilateral dispute, which means the patient also is raising this dispute, not just the lawyer. The lawyer can't unilaterally say that, oh, my client thinks that your bill is too high. And really, does that really make sense for him to bring that dispute up after he settled the case? If there was a dispute on the amount of your bill, shouldn't have been brought before the settlement was accepted by the client? Think about that for a minute. To raise the argument that your bill is too high after a settlement is a little hypocritical, because the lawyer went to the insurance company and saying, well, that bill is reasonable. Your bill is reasonable and necessary. And it is related, and it is everything that he can argue to the insurance company on behalf of his client. You know, that lawyer didn't go to the insurance company and say, oh, Mr. Insurance Company, Dr. So-and-so's bill's too high. I disagree with Dr. So-and-so's bill. So won't you make a lower offer than you should on this because his bill's too high? Well, that's a bunch of crap. And so that lawyer is trying to raise this argument after a settlement. And it's just a shakedown, is all it is. He made his best efforts to get an offer. He got that offer. Now, the insurance company may have felt that your bill may have been questioned, may have been unreasonable, or just wasn't usual and customary charges. And that's fine, because they argue that stuff all the time. Your bill could be $10 and they would still argue it. It really doesn't matter. So I don't really pay mind to the insurance company on as far as what they think about the treating physician's bills on behalf of my clients. But a legitimate dispute can arise. For example, it could be a billing error. You meant to charge for one area for treatment to a person's back, and then you accidentally charged for two areas. There was two areas that you charged for, two zones. Maybe the date of service was wrong. The patient may have said, I was in Branson that day. Here's my calendar. Here's my credit card. I was in Branson that day. I didn't treat that day. Well, it may be a calendar mistake. Could be a clerical mistake on the itemized bill or something like nature. Things like that can happen. Legitimate disputes can happen on that. And if it's a legitimate dispute, the lawyer's duty to you is to point that out to you and say, all right, Dr. So-and-so, we've got a duty to promptly pay you. We're settling the case. We want to get you paid. But my client, your patient, says that they weren't there on that day. Can you take a look at that? And then you look at it and you realize, oh, yeah, it's a different day, or it's an error altogether, and you correct it. Once you get past that, of course, the case is ready to be dispersed and paid. More specifically, the lawyer could really pay you the undisputed portion while you're trying to figure that other part out. How long does it take to figure out the dispute part? Well, it really depends on what the dispute is. It really depends on what the problem is. But the lawyer has a duty to promptly pay you once the case settles. Now, that can happen two ways. As you know, when you file a lien, your name is going to be asserted against a settlement, and it's either going to be on a settlement check or there'll be a separate settlement check issued. So if there's one check issued and your name is on that one check with the patient's name and with the attorney's name, possibly other lien holders as well on that, well, the lawyer has to go through and, promptly paying. Well, he's got to get signature authorizations, or he has to get signatures from all the medical providers before he can deposit that check. That check can take a few days to clear the bank. It might be 3 days to clear. It might be 10 days to clear, but there's going to be a clearing period on it. And once it's clear, it's ready to be dispersed. Your lien is to be honored at that time of disbursement if it's just one check. And the lawyer, obviously, he wants to get paid, so he wants to get everybody to sign the check. He wants to get it deposited, and he wants to disperse checks. So 1.15, saying he's got a prompt duty to pay you. If it's just one check, he's got a prompt duty to pay everybody. The patient, which is his client, you, and then any other lien provider. So he's kind of doing everything at one time. And I would say reasonable time period on that's probably about, 2 weeks, because he's got to collect people's signatures, and they might want to have some post-dated check in exchange for a signature, or they might do it through an authorization. The other means would be where there might be a separate check issued for your lien amount. And if that's the case, and if there's a legitimate dispute on that, well, really, the attorney can't pay you the undisputed portion of it, because that means he would have to deposit the check. That means you'd have to sign it or have a post-dated check or something of that nature. So I really don't see the check being deposited. What I see really on a disputed case is the attorney just hold the check. He holds it in the file, which we call it holding in trust anyways. And then he contacts you, and he has a duty to promptly contact you and promptly notify you that, hey, Dr. So-and-so, I've got the settlement check. It came in here, but we have a dispute at this point, and whatever that dispute may be. Again, a legitimate dispute would be one that just obviously is reasonable and makes sense. Can you have a situation where the attorney wants to hold the check and not tell you about it? Yeah, it happens quite a bit. And that's not really what the rules say. The rules say that really you've got to be notified. You've got to be provided an accounting. If you're the third party with a lien, which is Rule 1.15 is designed to protect you, he's got to notify you that. So he can't just sit on the file. They can't just sit on that check. And that, whether it be a MedPay check, or whether that be a liability check, or some other type of settlement check with whatever, like a slip and fall case, whatever the case may be. The attorney is supposed to notify you promptly about that and then get you paid promptly. Well, what if it's a MedPay check? I hear a lot of times, or I will see in my own practice here sometimes, that there's going to be a dispute over the nature and extent of the injuries. There's going to be a dispute over the liability. There's going to be a dispute over the injuries being related to the accident. And it may be that MedPay is not disputing it, but the liability is disputing it. Well, what does the MedPay have to do with the liability? In theory, really nothing. And so the attorney should contact you and say, hey, I've got the check, but here's the situation that's going to come up. I'm going to have to hold on to it till we find out what the liability is going to be, because honestly, if we get a situation to where the liability says that the medical is not related to the accident and they've got evidence, then I've got to hold on to this MedPay check until we can get that worked out. There may have to be a negotiation on the medical bill. I know everybody hates that. I hate that. When there's a negotiation on the medical bill, what that means to me is that there's a problem on the case that I don't think I can overcome in court. And so I'm going to probably have to reduce my fees too. I will most likely reduce my fees. In reducing my fees, I'll probably be contacting your clinic too and say, hey, look, we're not going to get retail value for this right here. There's only $200 worth of damage to the car. The client's got a pre-existing injury. They waited 2 months before they treated, or they treated and they stopped treating for about a month and there's gap in care. The client never missed a day of work, and you've got a $7,000 bill and they never missed a day of work and the insurance company doesn't understand. He was treating for the exact same injuries 2 weeks before this accident here. And so the insurance company's confused as to which accident caused the injuries. There's a whole slew of problems that can come up and complicate a case where I might want to take a look and figure out what that MedPay check and that liability combined together, what I can do to resolve the case. Meanwhile, you've got, the legitimate right to say, hey, look, I've got a bill out there and you've got MedPay, you're holding my MedPay check. Well, there's a legitimate dispute arising from that. And I'm going to have to figure out the fastest way to get that done, but I've got to figure out the liability first. That doesn't happen that often, but it does happen. Now, there are lawyers out there who routinely take the MedPay check and just not tell you about it. You may know about the MedPay, you may not know about the MedPay, but there may be something that's been presented unbeknownst to you. Your bill was sent to the MedPay carrier. There may be there may be lawyers out there who won't disclose to you that the patient has MedPay because they don't want you to know about it. And they don't want you paid so they can just kind of keep the money all in a big pot until it comes time to settling. That's different than what I was talking about when there's a dispute arising. They just want to do it from a standpoint of just holding on to the monies until they can figure out what to do when the liability monies come in, so they can make their arguments appropriately. Who knows? But I can't speak on behalf of the other firms, but I can tell you sometimes legitimate disputes do arise. But the Rule 1.15 says that we're supposed to promptly try to resolve those. All right, so we've got to do something. We can't just sit it in the file. Sitting in the file is not a prompt resolution. What happens if a lawyer is blatantly violating Rule 1.15? Well, I can tell you it's a rule of ethic. It's a rule of professional responsibility. And if we are violating that rule, we can be held accountable with the Bar Association through, I don't know, a suspension, a reprimand, or even, God forbid, some type of disbarment. There have been lawyers out there that have taken MedPay checks, signed the doctor's name to it, signed the patient's name to it, and cashed the check and nobody knew. They were caught, they were disbarred, and there's probably 3 or 4 of them that I'm aware of under the statutes of Rule 1.15 that talk about what happened to lawyers who do the wrong thing on Rule 1.15. So we take 1.15 very serious. And if a lawyer is being difficult with you for an unreasonable reason, and if he knows that you're aware of Rule 1.15, you've got the upper hand. Now he knows that he can't get one by on you. Now he knows that if you are getting jerked around by this lawyer wrongly, you can go to the Bar Association and ask for assistance and say, hey, look, I filed a lien. A MedPay check was issued like 4 months ago, according to the adjuster. I've not been paid. I call up the attorney's office. They won't give me information on it. Nothing. I don't know if the check's been cashed. No one's giving me information. I do know I have a legitimate lien. And let me go back a little bit and kind of disclaim this by saying 1.15 is useless to you unless your lien is good, unless it is all those 9 steps we talked about, you perfected your lien. If you have not itemized your bill attached to the lien at the courthouse when it's filed, it's not a good lien. If you've not sent it to your patient by certified mail, or at least got your patient to sign a waiver acknowledging the fact that they received it by hand or some other means and waived that certified mail. But if you don't have a perfected lien, 1.15 is worthless to you. You have a dead argument. You will not be able to do anything because there's no duty to protect a bad lien. There's no duty on the lawyer to protect an unperfected lien. It's only a good lien. And I know you guys get tired of me saying, what's a good lien, Lloyd? You know, what do you keep saying? Like I said, I know doctors out there that don't even file at the courthouse and send it off to the insurance company, never give it to their patients. Horribly bad liens, and they get paid. I don't know how, but if a problem ever comes up, they'll never be able to do anything with it. So I'm going to practice what the letter of the law is, and that's a perfected lien, and 1.15 is not good unless you have a perfected lien on that. All right, moving right along. 1.15, you guys have any questions on that? You can fire them up during this webinar, or we got one? Okay, and or we can you can email me, whatever you guys want. All right, how do you verify what the lawyer's telling you? You've got a pending lien out there. You call the lawyer's office, and really, hopefully, most lawyers are going to be very accommodating and giving you the information that you need on that. Obviously, their interest is to help your patients. Their interest is to make sure that the liens are been all taken care of, and the reputation of that lawyer hopefully is one to where you trust these people and what they tell you, you believe. But what if it's a lawyer that you've had problems with, and sometimes either they're not giving you information, or the information they're giving you, something's not right, something's not checking out with it. You know, you suspect it could be a misrepresentation or a flat out lie. Well, there's things that you can do to verify that. For one, if a case is, if one of your patients that this lawyer represents, if it's a lawsuit, Oklahoma has the website OSCN, that stands for Oklahoma Supreme Court Network.net, OSCN.net. You can go in there, you can go to case search. Under case search, you can put the last name and first name. If it's a common name, it's going to be a little bit more of a difficult search, but if it's an uncommon name, maybe it's easier. And you can pull it up. Maybe if you know the defendant's name, because if it's a lawsuit, the defendant's name will be in there as well, so you can verify it that way. Or you might have the case number, or the patient has given you a copy of the lawsuit. But either way, you can search it, you can pull it up, and in Oklahoma, it shows you the docket list. You can read day by day as to what's going on with the court. Is the case still pending? If so, where's it at? Is it set for trial yet? What if you see dismissed? Well, that's kind of scary. There's 2 types of dismissals. There's dismissed with prejudice, which means that case can no longer ever be filed again. The case is over. It's done. Either it's settled or the case was lost, one of the 2. The other dismissal is a dismissal without prejudice. That means it can be refiled within a year, but only once. In the state of Oklahoma, they call it the saving statute. The statute of limitations comes up every 2-year anniversary for the statute of limitations. let's say I file the lawsuit, but then I'm into the lawsuit and I realize that, wow, the client's still treating, or there maybe we can't find the defendant, I can't get them served, or something is a problem to where I'm just going to let it get dismissed and then refile it again, and I'll have another year to refile it. If I don't, then that statute of limitations is completely gone on that. But that's how you can check and see at OSCN what's going on with the case. But look at the little docket entries. What are the stages of litigation? Well, filing. Then there's got to be an answer period 30 days later. If the defendant doesn't answer, then it could be a default judgment, and then end of case. So filing, answer period, and then it goes into what's called discovery. Discovery is where there's interrogatories and depositions and these pleadings going back and forth discussing the case. That generally lasts between 6 months to 9 months. It can go on for years, but between 6 to 9 months is a discovery period. After discovery period is over, then it goes into that pre-trial motion, then a trial date basically set. And really you're kind of up to the court's calendar at that point. It varies from county to county in Oklahoma, but generally from the time suit is filed to the time it goes to trial, if it goes to trial, is about 1.5 years. That's what the average is. Now, I'll tell you my experience is when you file a lawsuit, the vast majority of them will settle somewhere along the way. And it may be the courthouse steps before trial, but most likely it's usually between the time of filing till the time after your patient, my client, is first deposed in a deposition. That's usually within the first 6 months of the lawsuit. The case is going to settle at that point. For a fair amount, for a realistic amount, whatever, but it's going to generally settle around there. So then you've got that way to be able to verify, talking to the insurance company, talking to the adjuster. Maybe they'll give you information where the status of it is. Is it pending? Do they have your lien? Is your lien good? If not, you want to make sure your lien is good. If the case is pending at any point, you can always amend your lien to make sure it's good if it needs to be good, or make sure it's certified in mail if you haven't, or get a waiver from the patient. If you don't have a good lien, you don't really have an argument to make if you have to. You can get burned really bad by not having a good lien. If you guys don't have those 9 steps, give me a call. Call Shelby. Shelby, lean over here. Shelby's over here. Hey. Call Shelby. She can get you all the 5-star forms. If you're 5-star members, we can get you all that stuff. The 9 steps, filing a lien. There's also a 9-star form for this dealing with lawyers, and that is really a response letter. It's a response letter for the next topic that I'm talking about, which is bill negotiations. We kind of alluded to earlier, sometimes as a lawyer, I don't get retail value on a case because of whatever problem it may be. It may be who had the green light, who had the red light, who had a property damage, a biomechanical issue, a pre-existing condition issue, a gap in treatment issue, a delay in treatment issue. There's some reason why the insurance company feels comfortable to defend the case, and that may lower the value of the case as far as trial possibilities. If we kind of lose a little bit in trial possibilities, then we're losing some in settlement possibilities. If they get to a lawyer early, the lawyer can a lot of times overcome this, reform those cases, and reshape it and package it back to the insurance company. If it's one of those people like, oh, I can get my own case resolved, and then they come to a lawyer and says, man, they're only offering me less in medical bills because of this, this, and this. Like, okay, well, it's a little proactive and reactive situation. Being reactive to a problem is more difficult than being proactive to a problem. So I might be able to get it resolved, but part of that may be negotiation. There may be multiple lien providers, maybe an emergency room, an ambulance, another orthopedic specialist in your bill. So part of the solution on resolving a bad case, a difficult case, may be bill reductions. The lawyer should reduce his bill if that's what's going to happen. Now, if it's a lawsuit situation, I don't see it happening. In a settlement situation, I can definitely see room for, as a lawyer, to say, okay, we're going to reduce it down as a pro rata situation. I'll reduce my fee the same percentage that you reduce your bills out there, and that's what we call pro rata. to create an incentive for the client so they can have some money to resolve the case. What's the option? The option is we do that voluntarily. If we don't do it voluntarily, the lawyer can file a motion to allocate funds or an interpleader action in the courts. What happens there is the lawyer then files this, and they say, okay, I've got this $25,000 policy limit offer, but yet there's $30,000 in medical bills, or $12,000 in medical bills, whatever the case may be. In an interpleader or motion to allocate, the attorney's fee is taken off the top, put to the side, no reductions. Then there's the balances looking at what goes to the lien holders. Now, again, only if you're a perfected lien holder. If you got a bad lien, you're not going to get paid. You'll get booted out. Something horrible is going to happen. So again, you make sure your lien has been perfected if you ever get an interpleader filed upon you or a motion to allocate. But the remaining dollars after the attorney fees and expenses, then you have this remaining amount that is dispersed to the medical providers pro rata. It could be 10 cents on the dollar. It might be 50 cents on the dollar that you're getting. Now, you are allowed to try to collect the balance from your patient, even though you received a certain amount from the settlement on that. Again, kind of good luck with that, unless they just happen to have a good job and a professional, and you can garnish them and maybe recover money that way. But that's what an interpleader does do. It allows you to be able to collect the balance. Now, that happens if we get a bad case and we try to negotiate medical bills to the providers, and the providers say, no, I'm just not going to cut my bill. And the attorney says, okay, well, I'll take the 30 minutes it takes to draw up a petition and go down to the courthouse and file an interpleader. And gosh, I'm going to get paid in full. And you're going to get pennies on the dollar. Plus you're going to have to pay an attorney's fee. If you're an LLC or a professional corporation, you must have a lawyer. You cannot represent yourself at an interpleader or motion to allocate. So you're going to have an attorney fee. So it's more expenses. Now, what I don't like is lawyers using this as a sword against you to beat you up. Like, well, if you don't cut your bill, I'll just file an interpleader. That's not a good way to approach it. The best way to approach it is hey, doc, it's not a strong case. I don't think that we're going to get more at trial. My experience tells me this is not a case that we want to spend $4,000 to $5,000 in expenses on top of attorney fees, because that's who's the only person who will get paid at trial. I think if we all cut our bills, including myself, and again, this happens in a settlement situation, you really won't see this in a lawsuit. Fees, by the way, for attorneys generally are less in a settlement. Once the suit's filed and once they proceed into the lawsuit, the fees increase for obvious reasons. It takes more attorney manpower hours to handle a lawsuit than it does a settlement. But so that's why we've got some latitude to voluntarily reduce our fee pro rata with you. Here's a trick to watch out for. If you ever get a bill reduction from a law firm that says, hey, I need you, it's a horrible case, we're going to lose, and I'm going to cut my fee too, and I'm not going to tell you how much I'm going to cut my fee, or they might be cutting their fee fairly, or they might not be cutting their fee at all. But where the case may be is they tell you one thing. After you agree to reduce your fee a percentage, they may go back to the insurance company and continue negotiations and get more money. I call that bait and switch. You've agreed to reduce in writing to a certain percentage. The attorney goes back and gets more money from the insurance company, but for whatever reason, fails to tell you that he got more money. So maybe you shouldn't have to cut in the first place. So the trick is on that, the bait and switch to avoid that is if you do agree to reduce your fee to the percentages, if there's a percentage reduction, then have a sentence in there on your agreement that says this reduction is null and void if this offer is increased by you. But if the insurance company ends up paying more money, this offer is null and void. We're only keeping this reduction assuming that the settlement stays at X amount of dollars. You can also put a time limit on there, say it's only good for 30 days. Sometimes I can see sometimes 60 days could be more realistic than 30 days. Depends on the complications of the case. But But be aware of the bait and switch. That's something that you see. In interpleader actions, let's just say that you're not going to reduce, or for whatever reason, the attorney went ahead and followed the interpleader or motion allocate, and then he serves it upon you, and then you've got to go get a lawyer to represent you on your bill in court. Look at the expenses of the case. And I've seen this, and this is really disturbing. You'll be served this interpleader or motion allocate, and of course, we know the attorney fees come right off the top, and it'll say what those attorney fees are. It'll also say what the expenses are. I'm seeing expenses of $2,500 for a case that wasn't really in a lawsuit. All they did was file it for the interpleader. How can you have $2,500 in expenses? First of all, it's only $230 for the filing of the lawsuit. The summons is $10 a piece. There may be 5 medical providers, maybe 10 medical providers. They're mailing out by certified mail. So we're probably seeing about maybe $350 to $400 expenses. What are they doing with that $2,500? That's disturbing. To me, if I was a clinic and I got served an interpleader or motion allocate, I'd want to see a breakdown of those expenses. I'd want those expenses provided to the court in an itemized fashion. Are they taking that money and are they passing it to the client? By the way, you can't do that. In an interpleader or motion allocate, the attorney can't take his fee that he's got off the top and split it with the client. He can't do that. He can do it with your permission, but that's more in that volunteer thing before the interpleader, before the motion allocate. Back when I was saying that there might be a letter that goes out that says, hey, would you guys consider reducing your bill, 15, 20, 25%, sometimes more. Depends on how bad the case is. Unfortunately, as lawyers, we can only be as good as the evidence. We can't get more than really what is fair on these things. I've settled cases for $4 million. I've settled cases for $0 just to get bills paid, or at least for medical bills. And sometimes the courts award nothing. So you don't know, but I can tell you from my experience, when a case is strong enough to move forward, not every case a lawyer takes is going to be one that's worthy of going to court. It costs the attorney at least $1,000 for every deposition he takes, and more if it's a video deposition. That's paying for your time, paying for the court reporter, paying for the videographer, paying for the transcript. Not uncommon to spend $4,000 to $5,000 in expenses on top of attorney fees to take just an average car wreck case to court. And that could be where your bill is $2,500 or your bill is, $7,000. It costs really the same amount of money on that. So we want to be able to settle as much as possible. We want to settle it quickly, and you really don't want it dragged out with the uncertainty of court. So these little tips I'm telling you really work both in settlement and in court, but you need to have that information before you make decisions. Call other lien providers. Call other, if there's an MRI facility or another doctor involved in here, and you've got a working relationship with these facilities out there, call them up, find out what the lawyer's telling them. Swap information, and that's another way to verify it. So when you've got an interpleader or motion allocate or any type of lawsuit, you can go on OSCN and you can track those cases to a certain degree, but communication is also key for you to be able to make a decision. Remember the bait and switch. They're telling you one thing, and then they go out and settle the case, but they don't tell you they got more money because you've already signed an agreement. They've given that agreement to the insurance company to show that you're going to take X amount of dollars on your bill, and then they get you a check cut for that amount. Or they may not tell you there's MedPay, or they may not tell you there's uninsured motorist. They may say it's just, oh, we've got this limited offer from liability for $25,000. There's just not enough money from the liability to pay all the medical bills. Did they tell you there's uninsured motorist, another $25,000? Maybe they didn't. Wow, that's wrong. That's just flat out wrong. But it can happen. It does happen. Did they tell you that there's $2,000, $5,000, $10,000 MedPay? Maybe there is, maybe there isn't. If they don't tell you that and they ask you to reduce the bill, aren't they misrepresenting a fact on that? And that's a violation of 1.15. They're asking you that they're come to you and saying, hey, there's a legitimate dispute, or there's a need for an incentive, not necessarily a dispute, but a need for an incentive to take a settlement offer and to get the client to say yes, where they'll sign the paperwork. And that's not a dispute. That's just that's just kind of really trying to figure out how to resolve a case that may not have good value to it. But if they're going to tell you these things, then they need to disclose to you everything. The med pay. They need to disclose to you uninsured motorists. They need to disclose to you where there's multiple defendants. There could be more than one defendant out there. They may be telling the truth about that one offer of being X amount of dollars, but they may not be telling you. They're omitting the reality of the other facts involved in that. Thank goodness 99.9% of lawyers out there don't operate that way, but there can be some that do. You just need to be aware of it. Again, if you don't have a good lien in place, it doesn't make a difference. Your lien is tantamount to, or paramount to be able to recover in these situations where you have at least the word to fight back. If you have to file and enforcing your lien on that, you can't do it on a bad lien. You can't go to court on an interpleader and really make an argument if you don't have a good lien. In fact, you may not even be served to go to the court and interplead anyways. I think that is, what kind of time have we done on that there?
1:36.
Okay, I think we've got a little bit more time to talk about what about out-of-state attorneys? This comes up from time to time. Some people will say, hey, Lloyd, my lien, is it good out of state? What if an attorney from out of state says that my lien's not good in his state? Well, let's take a look at the facts. If your patient is an Oklahoma resident, and if they receive treatment in Oklahoma, your lien is good against them. Now, you may not have jurisdiction against an out-of-state lawyer, but you have jurisdiction against your patient who lives in that state. Because your lien, if you remember back to Seminar 1, remember Title 42, Section 46A, Title 42, Section 46B says two different things. A is liening the patient. B is liening the insurance company. So if that attorney represents your patient has been put on notice, hopefully by certified mail, otherwise you don't have an argument, but your patient's been put on notice that there's a lien against the net proceeds that they get. That attorney has a duty in that state, regardless of what state he is, to protect your lien that's filed against his client. So if a lawyer is telling you that, one, he's lying to you. He's just flat out lying to you. And if that's the case, if you can get it in writing, that's even better. But I would ask his state bar association for assistance and write a letter that says, Dear Bar Association, John Doe, who practices in Dallas, Texas, told me that lien's no good. He sent me a letter, a fax, an email, or told me on the phone, better in writing though, that my lien's no good, even though my patient's in Oklahoma and I filed the lien in the county, followed the rules, Title 42, Section 46 says, and the lien's against the patient. So could you look into this bar association and find out what's going on with this, because this lawyer's not going to pay me my money. And I think you'll probably be pleasantly surprised to know that the bar association in that state doesn't really like a lawyer who lies to people. So if you catch a lawyer in a lie like that, I would definitely go to the bar association. But again, to be fair about it, what if that lawyer says, hey, look, I'm not sure. I've got all these other liens out here. I'm trying to figure out something here. Your lien may or may not be good. Well, if he's questioning at that point, then, do they have a rule of like 1.15 in that state? Most likely, yes, they do, because our rules of 1.15 were modeled off the American Bar Association's rules of professional responsibility. Most states, even Texas, theirs is Rule 1.14 in Texas, says basically the same thing as 1.15 in Oklahoma, that the lawyer there has a duty to protect third party and especially lien holders. So maybe that lawyer don't know. But if he's got a dispute, then he's got to promptly resolve that dispute. And he can't just unilaterally do it. He can't just say, your lien's no good because I think so. That's unilateral. He would then have to maybe file a motion in his court or something of that nature. You may have to have a lawyer hired in that area to represent you to appear in that court. Now, if it's an Oklahoma accident, it'll be in Oklahoma. But like I said, under my example, it's just an Oklahoma patient maybe they had an accident in Missouri or Texas or Arkansas, and maybe the actual jurisdiction for the lawsuit are in those states, but the treatment they received was here in Oklahoma. And that happens a lot. That's one of the most common questions I get about out-of-state lawyers. Try to do everything in writing, email, fax. Conversations are not a real good way to document anything, especially if you find yourself needing to go to a bar association. Well, he said, she said, that's just not really enforceable. So getting something in writing is the best way to there's a little trick. If somebody is doing something wrong to you and they're not doing it in writing, they're just telling you this over the phone, write a letter back and says, this will confirm our conversation as of this day where you said this, this, and this. Please get back with me as soon as possible, or I dispute that. So, you know, I dispute that, and I'm going to look into this matter on my own, but memorialize it in writing and send it to them. Fax it, mail it, whatever you need to. Certified mail, obviously, so you know that they received it. But that's a little difficult because if they never respond to that, then basically that's called acquiescence, silent acquiescence. They agree to what you say by the fact they never disputed it. That's one way to hold someone's feet to the fire who won't put something in writing. Just a little trick there. Little rule of Lloyd's negotiation right there. One I hear a lot of is, all right, my patient settled with the insurance company, or his attorney settled with the insurance company, and they didn't honor my lien because that attorney says that there's a problem with my lien. And so the insurance company settles and doesn't put your name on a check or doesn't issue you a separate check. And that attorney is going to hold harmless that insurance company. So the adjuster says, yeah, Dr. So-and-so, we settled that case. And your patient's attorney said that, and they filled out a hold harmless, that they have a problem with your treatment, or they have a problem with your lien, or whatever the case may be. And so they filled out a hold harmless. So now you just need to deal with the lawyer. Your dispute is not with us anymore, the insurance company. Your dispute is with the lawyer. Well, that's a bunch of hogwash. One, Title 42, Section 46 says that the insurance company has a duty, that lien's been asserted against them. They can't transfer that duty to somebody else. They can't say, you know, oh, well, we're no longer responsible because the hold harmless of this lawyer is replaced our statutory duty to honor your lien. No, that insurance company is still bound by honoring your lien. Of course, the attorney is. If the attorney ever does that hold harmless thing, it's what I call the good old boy system out there. That attorney has really put himself in harm's way and some hot water if he doesn't promptly pay you at that point. He better have a legitimate dispute. And again, we know a legitimate dispute when we see one. We may not like it, but if there's any sense of reasonableness to their argument, it's a legitimate dispute. But they've got to promptly try to get it resolved. And remember, they've got a duty to promptly pay you the undisputed portion. If they received a check without your name on there, in that hold harmless example, they settled with the insurance company. The lawyer gave the hold harmless letter to the insurance company. A check was given to that lawyer with just the lawyer's name on it and that patient's name on it, not yours, because remember, the hold harmless got you off the check. Well, 1.15 says he's got to pay you for that undisputed amount. So if the lawyer says, yeah, I was going to get with you on that, your bill is about 25% more than what it should be, and I've got a legitimate dispute that we're going to file for a hearing. Like, well, wait a minute now. If it's 25%, then you need to pay me that 75% that's undisputed at that point right there. That's what 1.15 says. So if anybody wants a copy of Rule 1.15, they can contact Shelby, and she'll get you a copy of that. So you have the wording of that. And then, of course, if you want a copy, if you're a 5-star member watching this and you want a copy of the response to the bill reduction proposal, even if it's one of my bill reduction proposals, I still encourage you to have the language on there. Remember, the bait and switch, I don't do it, but have the language on there anyways. Bait and switch is, by the way, that's to me a misrepresentation, and that's a violation of 1.15, by the way. And then limit your your reduction request limit to, I would say 60 days is probably a reasonable time period on that. All right, I think that pretty much covers everything here. If you guys think of anything, any other questions that come up, feel free to give me a call on that. I'm always glad to help you or your patients if they have a situation comes up. Remember, attorneys get substantially more than a patient can get without an attorney. You know, we want to get in there and grab that evidence. Video evidence disappears quick. And so if a patient's in a dispute situation, they need to get an investigator on that, a lawyer on that. They need to get the evidence before it's too late, before the insurance company takes control on that. So that's why people should call lawyers fairly early on and get a free consultation. Thank you very much, and hope to see you again soon.